We're going to continue with Chapter 4. First, we're going to look at the Napster case study. First of all, what is Napster? Napster allowed users to search for a particular piece of music from other Napster users' systems, as long as they had installed the Napster free file sharing software. So what you want to imagine is that Napster had a central directory that maintained a list of all songs and what computers they were on. And of course, because you had to download the Napster program, it registered you as a user. Once the piece of music was located, that song could be downloaded on the user's hard drive. How did Napster work? So you'll see on the right hand side a screenshot of what you would see for if I was looking, for example, for some reggae or for some funk or maybe a little Leonard Cohen. So what they did was they didn't store any music. Napster did not store the music. It did not copy the music. What it did was it had that central directory of music available among all Napster users. And that is what got them in trouble. So, for the first legal challenge in 1999, the Recording Industry Association of America, otherwise known as RIAA, sued Napster for copyright violation. And then, just to make matters worse, Metallica in 2000 also sued Napster for copyright violations. And you definitely don't want Metallica coming after you. Napster's legal team argued that Napster users were engaging in fair use of the music. And there are 4 conditions for fair use. 1. Purpose of use. Is it for commercial gain or for personal gain? So there's a significant difference between you downloading a song to listen on your iPod as you're going to sleep at night versus downloading a song that you'll then upload to YouTube as a video that you create for yourself that you then try to charge people to see, or for an artist who will pull pieces of music from another artist to include in their song. Second, the nature of the work. Is it creative or is it a factual creation? Meaning, is it a discussion of something that is already well known? So, explaining how a certain chemical reaction works versus singing a song about the chemistry 2 people have. So the latter would be creative, the first one would be factual. Number 3, the amount used compared to the full amount of the work. So, for example, if I wanted to bring in a chapter from a book, that would be considered fair use in the classroom. However, if I brought in 9 out of 10 chapters from a book, that would then be considered not fair use because you have the vast majority of the work being given to you. Last and not least are the effects of the use on the marketing of the work. So fair use should not materially impair the marketability of the work which is copied. So, for example, if I want to get the new Lady Gaga CD that's coming out, if I go and download it for free using Napster, I'm not going to go out then and buy the CD. Why would I? I have it for free already. Whereas on the other side of the coin, if I downloaded a snippet of a song just so I could create a ringtone for my phone, or if I wanted to just listen to the refrain over and over again, that would then be considered fair use. Napster also argued that in many cases Napster users downloaded a song to decide if they wanted to purchase the whole CD. And Napster users also downloaded MP3 files to listen to music they already owned on CD. This is a concept that was pretty popular in the 80s and 90s when we used to watch a lot of things on VCRs, and especially in the days before we had our DVRs and on demand. So, for example, if I wanted to watch General Hospital but I had to work during the day, I could record it on my VCR and then watch it that night when I came home from work. This was called time shifting, and it's not so relevant anymore, but it used to be extremely relevant. So the courts found that Napster did encourage and assist in the infringement of copyrights, rejecting its fair use claim. And after that, Napster converted their business model to one that is similar to the Apple's iTunes. However, iTunes does it way better, so Napster really hasn't done much since. Interestingly, one of the men who helped found Napster also worked with the people who helped found Facebook, so definitely a little bit ahead of the general trends. Now, did this stop file sharing? Well, of course not, as most of us already know. Today it's known as peer-to-peer file sharing, or P2P. This model does not have a centralized server that manages the file sharing, and that's the major issue here. It doesn't have a centralized focus that you can go after. Instead, the user logs into a peer-to-peer network and searches the other computers that are on the peer-to-peer network for the files they are looking for. The search continues from computer to computer in a giant web until it locates the file. And of course, organizations like the Recording Industry of America have fought the peer-to-peer suppliers like BitTorrent and LimeWire. In 2010, a U.S. court shut LimeWire down for violating copyrights. Interestingly, and we'll talk about this in a little bit, companies like BitTorrent are now making deals with the providers of content and becoming their partners in distributing the content. And this is seen as a way of, if you can't beat them, join them. The next case study we're going to look at is the DeCSS case study. And that was a software that was created to allow decryption of DVDs. The concept behind this is a Norwegian guy claimed it was to allow him to watch his DVDs on his computer, which ran Linux. And in general, most computers used by the population generally either have a Windows operating system or an Apple operating system. Linux is a free operating system, and as such, it's not set up to watch DVDs. So, of course, after he developed the code to decrypt the DVDs, he then posted the code on the internet and offered it free for anyone who was interested. The legal challenge came when a bunch of movie studios, otherwise known as Universal City, went after Ramirez, who was the name of the guy who essentially came up with the DeCSS software. The plaintiffs, the movie studios, claim that the DeCSS software violated the DMCA because the software created to jailbreak the DVDs. And you'll see I have a little picture there of how it works. The idea here is that when you create a software that is meant to jailbreak, that violates the usage of how we're supposed to respect the copyright. And of course, once a product is jailbreaked, then of course we can claim fair use. However, the jailbreaking of the material is in fact the part that's wrong. The argument was the defense team claimed freedom of speech. The plaintiff, meaning the movie studios, argued that software code is more functional than expressive and therefore not covered by freedom of speech. In the end, the judge ruled in favor of the plaintiff, which were the movie studios, saying that the DeCSS violated the DMCA, the Copyright Act. He also said that the software did not convey a message, rather it was functional and not worthy of free speech protection, which is exactly part of the issue we're dealing with now, is how do we categorize some software as being worthy of free speech protection and other software not being worthy of free speech protection. And that is where we currently sit in terms of the problems associated with copyright law and software. The next movement is called the open source code movement. And again, this is because most software does not fit neatly into any of the current intellectual property protections, like a copyright. It is usually written in a specific language, either C++ or Java. It can be considered literary, but it is functional, and that makes it inconsistent with copyright law. Code is also not worthy of a patent because although it is functional, it can also be an expressive literary work. Lastly, software is often innovative, but it's not inventive. At least that's the perception. So this organization, the Free Software Foundation, is an organization that argues that all software should be free. They claim that owning software is obstructive and counterproductive. And the general idea behind the open source code movement is that not only should software be distributed free, but the source code should be available to anyone who wants to modify it. The open source license contains 5 key provisions. 1, the freedom to run the program for any purpose. So if you pull off a piece of code that you would like to use for an app you're creating, that is fine. If you want to use it to set up a porn site, that is fine. If you want to use it to create a payroll system for your company, that is fine. The freedom to access the core source code to modify it. So again, what you're looking at is not only do you have access to the source code, but now you can go in and change the source code. Once you change the source code, you can then redistribute copies of the program. And then you also have the opportunity to release modifications to the public. Last but not least is the Copyleft Provision, and I'll explain that in more detail on the next slide. The Copyleft Provision allows a user to redistribute the open source code with modifications, but only under the same open source license. This prevents users from copywriting modifications to the source code. So, for example, let's say you take a piece of code and you modify it and you turn it into an opportunity, an algorithm that will identify certain users for marketing purposes. This is a tremendous boon for the marketing companies. However, because you started with an open source code, you should not copyright it, and you'll see the copyright signal on the left-hand side of the screen. Instead, you have to copyleft it, meaning it's not belonging to you, it is not for you to make any money off of, it is merely for you to put your digital signature that says, yes, I did this modification. Another option that some companies are going towards is called the trusted system architecture. And this is when a content provider has a particular system that you're allowed to download the work. So for example, if you look at a Kindle or a Nook, they distribute the content in cyberspace in an encrypted form. It is only accessible by the users who have that trusted system. So if I try to download a Kindle book on my Nook, it won't work. And the same vice versa. Now, there are, of course, people out there who are trying to jailbreak these systems every day. And what ends up happening is it's sort of the snake chasing its tail. As much as people try to jailbreak these systems, the companies themselves, like Amazon and Barnes & Noble, are continually upgrading their system to prevent jailbreaks and to change the code so that jailbreaks don't occur on a regular basis. This requires a lot of energy on the part of the content provider. Another option is digital rights management, which is something that Apple does. And this is the ability of the publisher of a work to define what rights subsequent users have of the work to use, copy, or edit the work. So for example, let's say that I download a song from iTunes. Well, I'm allowed, based on the DRM, to copy that song onto 4 or 5 different iPods. More importantly, when I want to create CDs, I am given a specific amount of CDs I can create. So if I download the new Lady Gaga CD and I make copies of it, after 4 or 5 copies, I'm going to get a note saying that I have exceeded my digital rights management and that I will have to re-download the CD if I want to make any more copies. This is an option for these companies so that they can continue to sell and market their product, and people will continue to buy it. The complication with both DRM and trusted systems is that it inhibits the consumer's right to fair use. And this is where we see the big issues nowadays, is what is fair use and what is not fair use. And we'll be talking about this in more detail on Wednesday.